SJC-12690, Boston Globe Media Partners, LLC v. Boston Police Department.
Ms. Dewar, good morning.
Good morning. Bessie Dewar for the Department of Criminal Justice Information Services and the Massachusetts State Police. The police departments in this case and the supervisor of public records followed DeCegis' regulation interpreting the Corey law to protect police reports containing charge or arrest-related information and booking photographs under the Corey law, and therefore that they were therefore exempt from disclosure under Public Records Law Exemption A. Superior Court should have upheld this interpretation of the Corey law for essentially three categories of reasons. First, it is consistent with the text of the Corey law itself in numerous ways and the legislature's evident intent to protect arrest-related information. Second, it's consistent with this court's long-standing understanding of how the Corey law operates. And third, nothing in either the 2018 or 2010 amendments to the Corey law disrupted this long-standing understanding.
You're probably not surprised by this question, but the 2018 amendment, such information shall be restricted to information recorded in criminal proceedings that are not dismissed before arraignment. Doesn't that assume that the criminal proceedings have commenced? Respectfully,
we do not read that provision in that way. The legislative history behind that provision is admittedly sparse but very clear in what we have, which was that amendment was introduced to provide additional protection where cases are dismissed prior to arraignment. In other words, the matter was so insufficiently serious that it was dismissed or, for whatever reasons, dismissed prior to arraignment. And it furthers the purposes, the rehabilitative purposes of the Corey law as discussed extensively by this court in both Pond and the recent show cause hearing case, which both acknowledge the extreme prejudice that can be caused by matters that are resolved at an early stage where a person does not have the right to, say, quote unquote, vindicate themselves in court and so forth. So this provision was put in to ensure that the Corey law, now it's important to keep in mind, the Corey definition does two things. It has two different functions. So the Corey law, as created in 1972, on the one hand, created a new statewide system for sort of the management and supervision of criminal justice information and the regulation thereof, and specifically created a new statewide database. And now, pursuant to the 2010 amendments, we have the 21st century version of that, which is, of course, the iCorey database, accessible by the internet. And in that system, the Corey law is concerned with protecting the integrity of that information, and as discussed in the Pond case, funneling requesters to the iCorey regulated system of accurate information. On the other hand, the Corey definition, so that's sort of, it's regulating the system as a whole, but the definition also operates to protect information. And the Corey definition provides that Corey information is information in any form held by any criminal justice agency regarding, including arrests and charges. In other words, it's a very, very broad definition. So we understand that sentence to essentially be kind of a belt and suspenders protection for these materials. As this court may be aware, the court activity record information, the carry, which is maintained by probation, my understanding is that the carry doesn't even commence until arraignment. And so there shouldn't be, pre-arraignment information in the carry and therefore in the iCorey database. And this provision was, as the legislator who introduced it said, intended to ensure that these pre-arraignment matters were not going to be disseminated pursuant to the regulated iCorey access provided in Chapter 170, in Section 172.
I have a couple of questions.
Yeah.
The first is that there is this statute called the Public Records Act. And it doesn't seem to me that the Corey Act exists in splendid isolation. We have to harmonize this with the Public Records Act and with the strong prohibition against, keeping things private and squirreled away. We have to construe the Public Records Act very narrowly, the exemptions to it very narrowly, and I'm not hearing you do that.
Absolutely, Your Honor. We absolutely agree that there's a strong presumption in favor of disclosure of public records. And what we have here with the Corey statute is an instance where the legislature itself has struck a balance. The legislature, as discussed extensively by this court in the Pond case, struck a balance in the Corey law, trying to weigh, on the one hand, the strong interests in public disclosure. And of course, as this court knows, the legislature actually increased access to Corey in many ways in the 2010 amendments. And then on the other hand, protecting information for rehabilitative purposes, acknowledged by this court as well. And the balance, the particular balance that that the legislature struck, I think, is particularly evident in Chapter 6, Section 172M, where the legislature expressly provided that, notwithstanding the rest of the Corey law, police arrest logs shall be public records. In other words, the legislature expressly provided that there would be an avenue, in addition to public court records themselves, which of course are not subject to the Corey law, but in addition to the court records, police departments shall maintain a public log for people to get access to this information. And I think it's interesting and extremely, it confirms DeSigis's and this court's longstanding understanding of the Corey law that in 2018, when the legislature added, as part of the criminal justice reforms, not only this new sentence to the Corey definition, but also new sealing provisions. And this is in 276, 100H, and 100L. And what these newly provided was that you could get expungement of events not even rising to the level of a conviction. And when you obtain such an expungement order, probation, DeSigis, and the court clerk are responsible for contacting the relevant police department and instructing the police department to expunge its own arrest log.
Can I just want to go back to the language of the statute, because I'm not sure how to get around the 2018 amendment that says, okay, here's what Corey is, but here, this information shall be restricted to information recorded in criminal proceedings that are not dismissed before arraignment.
So I want to just suggest that in reading and understanding that sentence, it's important to look at the sentence as a whole, and obviously in context of the statute as a whole. And what the sentence says is that that such information shall be restricted to information recorded in criminal proceedings that are not dismissed before arraignment. And we would submit that when the statute uses the phrase criminal proceedings, it's talking about when criminal proceedings exist. When criminal proceedings exist, the Corey information includes only those that are not dismissed prior to arraignment. In other words, there are criminal proceedings that are not dismissed prior to arraignment, and with respect to those, it all goes in the database. But if there's a criminal proceeding and it continues past, it actually is arraigned, then it's included. And I think that it's easy to understanding it in that way is consistent with what existed before in that sentence, which was repealed and were removed at the same time, which said that such information shall be restricted to that recorded as the result of the initiation of criminal proceedings.
How does this apply in the real world? Because you'd have to be blind not to notice that in some cases, the police release book and photographs on notorious cases all the time in police reports, and then here, there's a request by the Globe, and now it's a Corey violation to release a book and photograph that was released 2 days ago in a notorious case. So isn't that inconsistent?
Respectfully, we think that it's not inconsistent. And of course, we are here today because we would like the court to set a single rule that's applicable across all cases. And
Whenever the police departments do that in a notorious case, they're violating the Corey law.
And committing a
so
crime.
I think that if I may sort of go through a couple of the relevant parts of the statute that I think are really important here.
Is the AG going to prosecute them?
There absolutely are remedies available when Corey abuse occurs, and there are at least 4 that I'm aware of. Chapter 6, Section 177 provides a private cause of action, including damages, statutory damages, attorney's fees. Section 1678 provides for criminal penalties in certain cases. The DeSigis itself has a board, the Criminal Record Review Board, which is expressly established for the purposes of adjudicating Corey complaints. The record appendix at, I think, pages 132 to 136 contains summaries of 10 different cases where the board found a Corey violation between 2012 and 2016.
Of police departments?
including a number of police departments that are expressly identified in the record appendix at 132 to 136. And
They've been punished in some way?
there's one case where they were fined. There were
That's usually a police officer who's looking up records outside the book, so to speak, correct?
I think that is true for at least some of them. And there's a case cited in our brief, the Roggio case, R-O-G-G-I-O. We don't discuss it for this purpose, but that was a private cause of action brought by someone for damages because of sort of extracurricular Corey searching and so forth. And then further, just a fourth, I think that even Chapter 268A could come into effect here if someone is wrongly and unethically, out of loyalty, abusing their position vis-a-vis Corey. So there are lots of avenues for abuse, but I want to go back to not the situation of abuse, but what is the contemplated role of law enforcement vis-a-vis Corey? Because as the Bellin case from this court reaffirmed the reasonableness of DeCegis' regulation on this score, which says that law enforcement and this is quoting the 172 as it exists now in its exact terms, law enforcement can use Corey in the actual performance of their I think criminal justice duties is the phrasing of the statute. Of course, when a prosecutor stands up in court, when a police is interviewing a witness, when a police is talking to the victim of a crime, they may need to use and talk about Corey. And that's inescapable, and it's part of the tension of the Corey law, right? The Corey law provides a degree of practical obscurity to people, but it doesn't mean that our whole criminal justice system is secret.
All our town newspapers would say, this person was just arrested for drunk driving for the 5th time, and here's the photograph.
Well,
Right?
respectfully,
So we get that all the time. Is that a violation of Corey?
well, the question is here, what has the legislature provided? Should that be Corey or not? Should the police departments be able to, and in this case, of course, these are not requests.
Answer the question, yes or no, please.
Yeah, please.
So,
Is it a violation of Corey, what he said? This,
Is it a violation of Corey for the police to do what they routinely do, which is to release the police report and then have a photograph of the individual, so it's on the local newspaper that this individual was arrested, and here's what the police report says, and here's the photo?
the answer is no if it's contemporaneous to the investigation and prosecution pursuant to DeCegis' regulation at 7 CMR 803 CMR 710.
no to do it inconsistently. It's not a Corey violation to do it when it's a private individual, but it's a Corey violation to do it when it's a police officer's.
No, the relevant distinction is the
Isn't
timing.
that the way it's working?
The relevant distinction is the timing. The relevant distinction is that the Corey law protects against requests for historical information, compilations of historical information about individuals. If the Globe can request booking photographs pursuant to this court's decision, the Globe can request all the booking photographs going back in all of time
But the
for everyone.
Globe hasn't made that request. I mean, the request here, as I understand it, is they are looking for police reports and photographs of officers who were charged or arrested for OUI. That's at least one part of it, correct?
For the Mass State Police, it's two particular officers. For the BPD, it's actually all officers from 2012 to 2016
Who were charged with OUI.
who are charged with OUI.
Okay, they're not asking for the criminal histories of these individuals. They're asking only for whether they were charged with this particular crime.
They are asking for the police reports.
Okay, and well, let's stop there. Are those police reports filed with the complaint?
That may depend on the matter, and that's an important distinction here. And it
I
goes to
understand, because if they are filed with the complaint pursuant to Globe newspaper versus DA for Middle District, aren't they as public as the information in the court files?
Court files are public. The distinction between the Middle District case and this case is really important. I mean, the Middle District case, what was before the court was docket numbers, which inherently are copies of a court record. These records here are compilations of police departments, and they are not necessarily part of a court record if the case is sealed, if the case was never.
Okay, so,
me ask you
but yeah, let's go back to the question here. Have you checked with regard to these requests as to how many of these police reports were in fact filed in court and are not sealed?
In my case,
Aren't those discoverable under Globe newspaper versus DA from Middle District?
in my case, there are only 3 particular people involved, and I have not gone to see if there is a public court record regarding them. I do not believe that there are. Otherwise, the Globe wouldn't have sought these records from us.
Well, they would need the docket number in order to be able to find the case.
If there is no docket number, there is, that goes to my point, there's no
The question, I
docket
guess,
number.
is, I mean, well, let's step back. Juveniles are not within the scope of Corey, correct? Juvenile records, unless it's an adult.
That is the final sentence,
Okay.
yes.
So is it your view then that juvenile records have no protection under Corey and therefore would be discoverable, not discoverable, would be public records and would not be protected by Corey?
Absolutely not, Your Honor, which is why that's exactly consistent with our reading of the new second sentence of the Corey definition. These exclusions from the Corey definition are precisely to protect that information, that it not be in the iCorey database.
Okay, but you're saying that this is protected because it is within Corey, and then you're saying, well, juvenile records are protected because they're not within Corey. So if they're not within Corey and you're arguing that Corey protects them, how are juvenile records protected under Corey?
We think that juvenile records are, and we have argued, are protected under Corey by necessary implication of the statute, which is to say that the clear intent of the legislature was to protect juveniles, was to protect cases dismissed prior to arraignment, was to protect, in the final sentence, protect cases where it's not punishable by incarceration. We have to read the statute as a whole. Chapter 167, Section 167 expressly says at the beginning, in the preface to the definitions, that these terms shall have the following meanings unless context dictates otherwise. And we think this is the most harmonious reading of the statute as a whole.
But isn't that the problem with your argument? Is that the purpose of Corey, as it has been understood at least by the court system and working on our public portal, is that we will not permit somebody to do an end run around Corey by finding a different way to get someone's full criminal history.
Agreed.
It does not protect individuals from being able to identify particular criminal acts by going in and finding out what happened with regard to a particular incident.
Respectfully, the Corey definition protects Corey information in any form.
Okay,
And going back
but
to
therefore doesn't protect juveniles because juveniles are not within Corey. So I mean, you have this problem is that you're contending that this is protected by Corey, and then when there's information which is not protected by Corey, such as juveniles and individuals who's had their cases dismissed before arraignment, you're saying, oh, they're protected by Corey too. But the only thing that's consistent is that the legislature wanted to say, we don't want this part, we don't want cases that are dismissed before arraignment to be part of an individual's criminal history, and therefore when you ask for John Smith, and John Smith's had a prior arrest which was dismissed before arraignment, you won't find that when you get John Smith's criminal history.
That's absolutely the way that it should and does work. And the problem in this case is that what the Globe is seeking to do is itself create an end run. And of course, the public records law.
How are they seeking to end run?
The public records law does not discriminate among requesters, right? And it doesn't, and the Corey law does not discriminate among subjects of Corey. So if the court in this case were to rule that the Globe, on the one hand, for clearly public interested reasons, can get this information about these police officers. That also means that database companies, discussed by this court in Pond, can likewise request every booking photograph from every police department of every individual booked. And states, as highlighted by the newspaper publishers' amicus brief, states have taken different policy approaches here, and some states do keep booking photographs private, as does the federal government. So the question here is, what is the balance that the legislature has struck? And we submit that based on the Corey definition, which protects this information in any form, and in which this court has long understood that to be the case, the Reinstein case from 1979, under substantially the identical Corey definition, was all about whether police reports were Corey protected, and the court said that they were insofar as they contained Corey information. That was from 1979. Nothing the legislature has done since then has disturbed that understanding of the Corey law. I realize my time has long gone.
I understand, but I mean, so do you agree that it is a legitimate matter of public interest as to whether the police are appropriately handling individuals who are police officers who've been convicted of OUIs when they're responsible for arresting individuals for that crime?
Of course.
Okay, so how are they supposed to find this out?
Well,
if you're going to be blocking them from learning what has happened, they don't even know which officers have had OUIs. How are they going to be able to evaluate whether or not the police are acting appropriately with regard to individuals who have been accused and charged with crimes.
There are a host of different ways of
Like what?
discovering that, and
Like
I
what?
would, a good example is highlighted by the court's recent case in the show cause hearing, the whole show cause hearing case in the decision published in September, in which the court pointed out that under Trial Court Rule 14, even though denied applications for criminal complaints are typically not public and are kept segregable, under the Trial Court Rule 14 and the trial court's internal practice rules, a party like the Globe who has a public interest in disclosure of materials can seek access to those materials. And of course, a denied application for a criminal complaint would include the police report, usually the police report, one would assume, booking photographs and so forth. And that's what's alleged to have occurred with the judge incident.
I know that language, I wrote it, but tell me how it helps you, because that says that it is a matter of public interest when public officials are being accused of crimes, and therefore the release of it for an otherwise confidential proceeding is at its apex. So,
Absolutely, and that's...
but you still haven't told me how, if there is a concern, or at least a desire to inquire as to what the police, how the police are handling individuals who have themselves been charged with crime, how is that to be done?
Well, I don't want to repeat myself, but as the court held in the show cause hearing case, Trial Court Rule 14 provides a really excellent mechanism for this in the sense that it expressly, disclosure or not, is based on the public interest. And so an ordinary person who's just an ordinary person, there wouldn't be a lot of public interest in obtaining a denied criminal case complaint with respect to them. But a public official, there could be a lot of public interest in that information.
But there could be a public interest. Say, suppose we wanted to look back in time and say, let's look back, and we asked the police department in New Bedford, give us the last 10 convicted people who've been convicted all over, the case is over, and give us the police report and the complaint so we can follow how they've been doing in their life.
Well, clearly under the court records exception, a whole bunch of that material would be public, and would be
Would the
public.
booking photo be public?
Anything that's in the court record is public and available to the public. But with respect to police departments' compilations of police incident reports, the legislature has clearly established that the mechanism, and this is another way of shining light on what is actually occurring and so forth, is the police arrest log. And that is established by the legislature as a place to find this information. I would also note that the legislature clearly is concerned about this arrest information, and in the 2018 criminal reforms established a whole new requirement that DeCegis, and this is in 172, excuse me, I'm not getting the citation immediately, but it's, oh yes, in 167A sub I, requires newly that DeCegis collect a lot of arrest data, including the race and gender and age of arrestees and so forth, and publish it on an anonymized basis. So the legislature is clearly very concerned about that arrest data be available in some forms, but they just want to keep it protected for ordinary people who are trying to go out their lives and not have, websites extorting them, try to sort of pay money to take down your mugshot from online, and you type in the person's name, and the first thing that comes up is, a mugshot from an incident that wasn't even ever prosecuted, which is incredibly prejudicial, as this court recognized in the show cause hearing case.
So you're saying that if, in fact, the mugshot had been part of the court record, then the Globe could get that information?
The Globe could get that information from the court.
But they could not get it from the police department if the case was over?
Correct.
Okay.
But I still don't understand how they're supposed to know how many police officers, say, in state police have been arrested for OUI. How are they supposed to know that?
I think one could submit a public records request to a police department that wasn't requesting the police incident reports or the booking photographs for that information.
Okay, how are they supposed to find out what actually occurred and be able to evaluate whether or not they received special treatment?
You could request use Trial Court Rule 14. You could look at the arrest logs. The information, these particular incidents, the two incidents that
both of the arrest logs, I have to go through every arrest log for every day, and then I compare that to the names of every state police officer.
My understanding is that the our press does closely follow arrest logs. They literally publish them. And, the cases here regarding
But, I mean, yes, they could, in theory, go to all 99 courthouses and check every single individual, but of course, the question, I guess, is why is it, again, we're not speaking about give us every arrest record for all persons. They're asking only with regard to police officers or state police officers, state troopers who have been arrested or charged with OUI and trying to find out whether they were treated differently.
Well, the problem is that the Corey law does not contain a general public interest exception or public official exception. Even public officials have Corey protections. Now, there could be ways around that, for example, through Trial Court Route 14, getting these information from the courts and so forth. But the Superior Court's declaratory judgment below, which did hew only to public officials and police officers, has no basis in the actual statute. The legislature has obviously a lot of concern about balancing the clear public interest in disclosure and the rehabilitative interests. And the balance that they've struck is, with respect to police incident reports that concern an arrest or a charge and booking photographs, that those are protected by the Corey law.
All right, thank you.
Thank you.
Mr. Lederman.
Good morning. May it please the court, my name is Jason Letterman, and I am here as Assistant Corporation Counsel for the City of Boston, representing the Boston Police Department. Boston Police Department is asking for this court to reverse the lower court's ruling and find that a CJIS regulation is a reasonable interpretation of the statute and therefore due deference. The Boston Police Department is adopting the Attorney General of the CJIS and Massachusetts State Police position, essentially that the core protections do go into effect at the time of arrest. Additionally, I'd like to draw the court's attention and highlight essentially the difference in the request that the Globe made to the Massachusetts State Police and the Boston Police Department in this case. As the court noted previously when my sister was speaking, the request to the Massachusetts State Police was for 3 specific incidents that they were aware of at that time. They were granted not explicitly contemporaneous with the original incident. However, the request of the Boston Police Department was for 2.5 years, or a little bit more than 2.5 years, of incidents from January of 2012 to October 21st of 2014. Certainly.
I'm sorry, but limited only to Boston police officers who were themselves arrested for OUI.
Yes, Your Honor. But
not
the Boston,
asking for every arrest the BPD did.
That's correct, Your Honor. But the Boston Police Department's position, and I believe that the AG's position would also be, that essentially the Corey applies or it doesn't apply. In this situation, there is no carve-out in the statute for police officers.
But does BPD release booking photographs routinely?
My understanding is they do not release booking photos routinely. And in fact, the lower court found in its order that the Boston Police Department releases only contemporaneous information with arrests, and additionally that historical information, which certainly would not be contemporaneous, is released only with non-identifying information, which would be consistent with how they responded to the Globe's request in this case.
So there's a notorious murder. Does the BPD release the police report in the book and photograph to all the newspapers?
My understanding, Your Honor, is that BPD may release in the police logs, certainly contemporaneous with arrest, the information that it's required to release in those logs. Additionally, there may be a release regarding, I'm not sure if this is contained directly within the record, certainly, but there may be a release of information that is contemporaneous with the arrest, but that would be supported by both the CJIS regulations found in 7.10 of the CMRs, as well as the Bellin case, which this court has opined regarding.
So the distinction you're drawing that we're asking about between the search for book and photographs and police reports would be this contemporaneous with arrest exception?
Yes, Your Honor.
And have you checked to see whether any of these police reports were in fact filed with the court as part of the complaint?
Your Honor, I did not check.
Isn't that, are they not publicly, are they not public under our, if matters are publicly available and in the files of the police department under Globe newspaper versus DA, are they not public records?
Your Honor, if there are records that are contained within the court record, certainly, given the holding in that case, those would be public records from the court.
Okay, and have you given them, you said, okay, we'll give you the docket number and you can find that?
Your Honor, I don't believe that the alternative was that we would provide the docket number. What I can tell the court is that the Boston Police Department did respond and in fact provided the police reports without identifying information. So the information was given to the Globe.
But how is the Globe going to use that to determine whether or not these individuals were appropriately disciplined or treated appropriately?
Certainly, Your Honor, I understand that there's a public interest that the press receive this information, but the legislature has expressed a clear public interest in collateral consequences not being held against certain individuals. There is no exception in that statute, in the Corey statute, for collateral consequences that may affect police officers.
Those individuals' records are publicly available. If they were to know who they were, they could just go to court and find out what happened to their case.
Yes, Your Honor.
So your view is that the Corey law protects not only the aggregation of criminal histories, but it protects all information regarding an individual regarding a particular case.
Your Honor, we would argue that in this case, this is in fact an aggregation of criminal history. There was a historical request for 2.5 years worth of information. That is not a simple contemporaneous exception found in the CJIS regulations. That is a request for 2.5 years of past information regarding alleged criminal conduct.
But with regard to an individual police officer, it would only be a criminal history if that particular police officer has a criminal history while working for the BPD.
Yes, Your Honor, that is correct.
Is that not a matter of public interest if that's the case?
Your Honor, we're not arguing that this isn't a matter of public interest. We do believe that it's a matter of
but
public
just
interest.
essentially the interpretation that you're giving to Corey, which is that the legislature intended to frustrate and prevent this type of inquiry, even though the public records law is meant to be expansively interpreted.
That's correct, Your Honor, except that there is the exception in A, which deals with any statute that deals with necessary or impliedly restricting access. And in this case, Your Honor, given the expansive analysis this court has done in both Pond as well as the most recent case, show cause hearing case, certainly there is an understanding that collateral consequences, regardless of what you're employed as, are very real and will prevent people.
Quarry's not the only statute we have. Quarry and the concerns behind Quarry, rehabilitation and the prospect of bulk purchases is not the only public policy concern we have. We have to read Quarry and knit it into the public records law and the recognition that open government is important. And isn't that a fair prism in which to interpret these provisions, other than just saying, well, Corey says X, Corey says Y?
Your Honor, I certainly understand the court's question. I would argue, Your Honor, that there are exemptions under the public records law that deal with something that the court is concerned about. Those would be the privacy exemption and many other exemptions that are specifically enumerated by the legislature in the public records law. However, the statutory exemption in A is very clear that if it is withheld under Corey or withheld under any statute that protects this information, it is withheld. It is not to be disclosed. That is a different analysis than I believe the amici did in the ACLU brief specifically regarding conflating essentially the privacy exemption with the statutory exemption. They are different exemptions, and the BPD's position would be that if something withholds the information under the statutory exemption, there's no discretion in that case, and it needs to be withheld unless the CJIS promulgates a regulation that gives discretion in that case.
And have you invoked the privacy exemption or the exemption for investigative information?
Generally, Your Honor, yes, we have.
In this case?
In this case, Your Honor, I do not believe that it was.
So you rise and fall, this case rises and falls on your Corey interpretation?
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
Mr. Albano.
Good morning. May it please the court, John Albano. I believe analytically the starting point here should be that the records at issue are made or received by a public employee, so they do meet the definition of a public record under Chapter 4, Section 7, which means that there is a presumption that the records are public, and which means the custodian bears the burden of proving the applicability of any exemption. Here we say the Superior Court was correct in making essentially two related rulings. First, that Corey does not prohibit, on the pain of criminal prosecution, the disclosure of booking photographs or police reports regarding public officials. And second, as the Superior Court also made clear, that ruling does not mean that every booking photo and every police report is immediately available upon demand because, as the Superior Court said, there may be, depending upon the facts of a case, an applicable privacy exemption, there may be an applicable investigatory exemption, or there may be another statute that applies that prohibits disclosure. But it is not the Corey statute that prohibits disclosure here.
How about for the ordinary person? You know, it's very tempting to say that the statute means one thing when you're talking about police misconduct allegedly and how it's dealt with. But how about the ordinary citizen, the one that, you know, just got into a bit of trouble and, you know, we really want to protect this person?
Right.
And how do we do that?
The answer is that the privacy exemption should be analyzed in that instance, and there are other statutes that may apply, Your Honor, but it's not Corey. So, for example, a case I didn't cite, I should have. I think one of the amicus cited, the Sixth Circuit case, Detroit Free Press, which gets sold as, oh, this is a bad case for public disclosure of booking photographs. That case is actually very consistent with Judge Wilkins' ruling, because what the court said was, we no longer will adhere to the view that there is zero privacy interest in a booking photograph. We're abandoning that view, the Sixth Circuit said, and they acknowledge states come to different conclusions on this. But in a case involving, that case did involve police officers, we're going to remand it for a balancing under the federal investigatory exemption, which includes a privacy component. So here what Judge Wilkins said was, if it's not a public, obviously the privacy equation is different in a private individual than with a public official. And I want to be clear, I'm not suggesting that there are no circumstances in which a booking photograph of a private person should be made public. I am saying that that would be a fact-intensive determination based on the request and the situation, and not at all a function of the Corey Act. And the Superior Court correctly looked at the statute and said, at the time the court made the ruling, that in order to be Corey, it has to be recorded as the result of the initiation of criminal proceedings. And he correctly ruled that if criminal proceedings have not been initiated, it can't fit the definition of Corey. After the amendments, I would suggest that that outcome is even more clear, because now the definition reads that it's restricted to information recorded in criminal proceedings that are not dismissed before arraignment.
Mr. Albino, what do you make of the legislative history that they reference?
Pardon me?
The legislative history, what do you make of that legislative history saying that it really does not go your way?
I respectfully disagree for
Could you tell me
two
about the
reasons.
legislative history?
Let's leave aside the plain meaning of the statute, which Judge Wilkins relied on. I think the legislative history demonstrates that after the amendments to Corey, the prohibitions on public access are limited to requests for the information from the department's database. And if I may, let me explain why. Before those amendments, old Section 172 used to say, just give me a second to find it here, it used to say, except as otherwise provided, criminal offender record information shall be disseminated, whether directly or through any intermediary, only to criminal justice agencies, certain other authorized persons and entities, and if the Corey board at the time said, okay, you can have it. Prior to the amendment, the Corey Act also prohibited the disclosure of alphabetical arrestee indexes and alphabetical criminal defendant indexes. Those were all swept away when the statute was amended. So now, I just suggest as a matter of statutory analysis, we have to look at the statute and say, okay, we've got a definition of Corey. Whatever that definition may be, I'll take any definition one comes up with today. We still have to look elsewhere in the statute to say, okay, where does it say thou shalt not disclose this particular criminal offender record information? And when you look at the current 172, it clearly says is limited to requests to the department, and it lists 25 persons and entities that can get access by requesting the department. Now let's look at the surrounding sections of the statute. So if you look at 172B, 172C, and 172E to 172L, all of those sections, all of them, have the language, notwithstanding section 172, we're going to let someone else have access to the Corey through the department. That's the way the statute works now. 171A makes it clear that Corey can be obtained from other sources because it expressly says that it provides a rule on when the holder of Corey has to provide it to the subject, and says that rule applies whether you obtain the Corey from the department or any other source.
Can I
So-
ask you,
yes.
we had some questions for your sister about whether or not it was a Corey violation for the police departments to be giving out booking photos and so forth of individuals who were just sort of ordinary citizens. What is your position on that? Is that a Corey violation?
Well, of course, I say it's not a Corey violation because I say Corey does not prohibit the disclosure of any of this information. As I understand
It's a Public Records Act violation, or it's not an exemption under the Public Records Act?
It's, right, it would not be a violation of Corey
Okay.
to disclose those records
So
at any time.
If the Boston Globe stands in the same position as any other individual,
Right?
so if I am a landlord in Boston and somebody comes to me to seek to rent an apartment and I want more information than I could get from DeCegis, can I make a request for this particular potential tenant to the BPD and say, give me all information regarding this particular tenant that's in your possession?
One could make that request, whether it was granted or denied, should not turn on the Criminal Offender Record Information Act, because that act, which, by the way, imposes criminal penalties, simply does not prohibit the disclosure of that information.
Isn't there the same risk of the end run around Corey that we would be concerned about in terms of by implication? There are certainly limits on what that landlord could get if the landlord went to DeCegis, correct?
Yes.
But if the landlord went to the Boston Police Department, he or she could get far more, could they not?
Well, let's think about what it is they could get from the Boston Police Department. If they had a name and they asked for a booking photo, they had a name and they asked for a police report, the Boston Police Department is perfectly capable of saying that's exempt under Exemption C, because under the privacy exemption, if the investigation was ongoing, they could invoke Exemption F. I am here to say they should not be invoking the Corey Act because I cannot find in that statute, as it currently exists, the clause that says, thou shalt not release police reports, police departments, thou shalt not release police reports or booking photos. I say it's not in there. Can I go a little bit further? I think the best argument that the Commonwealth has for whether there is such restrictive language in Corey is in Section 178, which is the section that imposes criminal penalties. But so I call that to your attention, but I think when when one looks at 178, it doesn't get you there.
But the public records speaks not only about specifically exempt from disclosure by statute or also by necessary implication. And, I mean, we in the court system struggled with this in determining what's going to be available on our public portal. That, you know, we were concerned that if we could do it by name, you could identify John Smith and identify all of the cases that John Smith had, and that may give you far more than you could get if you did a query request. You may not even be entitled to do a query request. Don't we have to do a comparable analysis here with regard to BPD records or state police records?
Well, I certainly agree that the correct analysis is there anything in that statute that either expressly or by necessary implication prohibits disclosure? I'm saying when one examines the statute, there is not. It would mean, for example, it's really a penumbra argument, right? It's really saying, well, if it's been 7 years or 3 years since you were discharged, the legislature said you can seal your records or maybe you can even expunge them. And so they have a concern about that. And they have a concern over here that they've expressed in another statute. They never say that the Criminal Offender Record Information Act prohibits disclosure of this information, but we find it in the penumbra. That, I think, would be wrong for two reasons. First of all, it's a criminal statute. People can be prosecuted for violations of it. The prohibition should not be found in a penumbra. Secondly, when you think about what kind of additional information would fall within the statute and be criminal, the disclosure of which would be criminalized, one would have to consider things like the press releases that district attorneys properly release upon an indictment or upon a conviction. That's criminal offender record information.
Let me go back to your really lengthy argument that you just made. So what if the context isn't a criminal prosecution? Rather, it's a determination of whether or not to turn over booking photos to the Globe. Do you nonetheless interpret query utilizing the rule of lenity because there could be a criminal prosecution?
As I understand the Commonwealth's position, it is that one violates query by releasing a booking photo, which would mean that disclosure is a crime. And I say that is one reason why, in the absence of any, I say any language, but certainly any explicit language saying one cannot disclose that information, the statute should not be interpreted that way. Again, I think the Superior Court took the most direct route. The Superior Court said, I'm looking at the definition. You need a criminal proceeding to have been initiated.
They have a different view of that language because what was deleted as far as the initiation of criminal proceedings, the whole point was to expand protection, and your interpretation limits the protection of query. That's the argument we heard.
Well, I think my interpretation says, with respect to these requests, it remains the same. But if I could go further, I think the amendment underscores that the current language and purpose of the Corey Act is limited to the department's database. That's why it made sense to say, to use the language that they use, recorded in criminal proceedings that are not dismissed before arraignment. The focus is what is going into that database. And the reason, there's many reasons for that. There's policy reasons, there are compilations, it's a lot of different types of information than is at issue here, but it's also because that is where the prohibitions, and only where, the prohibitions on disclosure are found under the current version of the Corey Act.
So in your interpretation, if an individual is charged with say, possession of marijuana with intent to distribute, and that case is dismissed before arraignment, so therefore would not be part of Corey, and a criminal history check of that person would not reveal that charge, you're saying that would still be a public record if they went to the police department itself and said, give me all such records of arrest?
I'm definitely saying Corey would not prohibit the disclosure. I also believe that the privacy analysis under Exemption C would be highly relevant to the answer. And if I may, the same analysis has to apply. Let's say they're dismissed before arraignment as under this hypothetical, but there has been a public disclosure of the arrest. It was reported in the newspaper. Maybe there was even a press release. If the Commonwealth is right, then that press release can never be spoken of again, because that is criminal record information. The case did not go to arraignment, and therefore it is a crime to disclose or discuss the contents of that press release. I suggest the statute cannot reasonably be read that way. That's not what the statute's about, at least as currently constituted.
Okay, thank you.
Thank you, Your Honor.